State Court heard appeal in the matter of Rail Infrastructure Ltd and Mr Karl List.
Yes, Ms Ward.
Good morning, my lords. Firstly, my lords have two short clips that I've handed up. One is further regulations from the 2005 regulations, and that's in response to my Lord Justice Holgate's question about section 64(2)(a), and I will deal with that very shortly. Secondly, what I hope when I come to my submissions on legislative history will be a helpful table that will speed things up, rather than require us to keep flicking backwards and forwards through the bundles. The legislative history is where I promised to go next at the end of yesterday. Just before I do that, three matters. Firstly, I said I would tell you which out of myself and Mr Flanagan would cover round 4. That will form part of my submissions this morning. Secondly, to pick up on my Lord Justice Holgate's question from yesterday and section 64(2)(a) about electricity meters. Those are the subject of regulations 11 and 14 in the 2005 regulations, the central list regulations that we've been looking at behind tab 3 of the authorities bundle. As my Lord Justice Holgate said yesterday, I think most of us in court rather assumed, got the impression that there would be some prescription of large electricity meters to put into the central list. It transpires that there was one person in court who knew that that wasn't correct because it was the person who is responsible for the central list. And the answer actually is that every electricity and gas meter in all of our homes is part of a central list hereditament. That's the consequence of regulations 11 and 14, the 2005 list regulations, central list regulations, which I've handed up this morning. The schedules to which they refer are at pages 42 and 46 behind tab 3 of the authorities bundle. There's no prescription of types of electricity or gas meter. On more careful reading, what section 64(2)(a) does is enable also regulations to be made prescribing other types of meters, but so far as we're aware, there aren't any of those. So section 64(2)(a) provides that if a hereditament consists of an electricity or gas meter, it will be a separate hereditament, and the central list regulations provide for all of those to be merged into single hereditaments in the occupation of each of the electricity and gas suppliers. I don't think any of us feel that it moves the dial on any of the issues in this case. It's just simply for completeness and Lord Justice Holgate's questions. Well, they are deemed to be in the occupation by, and that's in regulation 14. It's perhaps a little bit more straightforward in relation to electricity meter hereditaments. A company which is a designated person by virtue of regulation 3.1, that's the regulation you've already seen that prescribes the hereditaments in the schedule to the persons named in the schedule. Part 9 of the schedule, which is what appears at page 46 behind tab 3 of the authorities bundle, which lists the various electricity companies and prescribes to them the hereditament described in regulation 14.1. And then where such a company or any other person occupies, or if it's unoccupied, owns what would, apart from these regulations, be more than one hereditament. So all of these electricity meters scattered through all of our homes And each of those hereditaments is an electricity meter attached to the end of the electricity distribution network, which is defined in Regulation 13, and we've handed that up as well for completeness. Yeah. Then those hereditaments, all of those individual electricity meters, are one composite hereditament in the central list prescribed to the relevant electricity company, and by Regulation 14.3 to be treated as occupied by the relevant electricity company.
We're not concerned with letting out.
We're not concerned.
64.2a doesn't.
No, it's not about letting out. No, it's simply a
the right to use the land.
yes, exactly that. So that's simply a tying up of a loose end. And then finally, before I move to my submissions on legislative history, just to confirm, I was asked a number of questions by the court yesterday, which I answered without instructions. Happily, my instructions are that I got the answers right, so we don't need to spend too much time on that. In particular, in relation to the question about the letting out of advertising rights for not for the whole time, so for 50% of the time or 70% of the time, that is something that happens. So I may not have been entirely right to say it's not something the valuation officer has considered. In fact, they have. It does happen. It's referred to, not in a way that sheds any light on the issues, but simply in a way that shows that it is something that happens in a section of the rating manual relating to superstores, that some superstores let out the right to advertise for a percentage of the time. And those lettings out are in the list, and it goes to valuation. And when I said there will come a point at which it's de minimis, there will come a point at which there is no value.
So if you were a superstore and you let someone put adverts up every Monday,
yes,
that's still
a letting out.
It's still a letting out. It's still a right to use
yes.
the land for advertisements. And
yes.
the fact that the supermarket puts its own adverts there
the rest of the
6
time
days a week doesn't matter.
Yes, because it's let out on a Monday and it can't put its own adverts there on the Monday.
So it's an example of an exclusive right being given on that day of the week.
Yes, exactly that.
And the statute proceeds on the basis of daily charging.
Yes.
So it's full value for those particular days of the year, is it?
Yes. So the only way in which I may have slightly misled the court to say the valuation officer hasn't previously considered it. The valuation officer has considered it, and it's dealt with. So if I can move then to the second part of my substantive submissions, which is the legislative history. I don't propose to trawl back through the history to the 19th century. All I propose to do under this heading is to trace through the changes, the scheme under the 1967 Act, and where the equivalent provisions are to be found in the modern legislation, which of course is a combination of the 1988 Act and then the various sets of regulations that have been made. And just to flag where I'm going with this, my submission is that you can see that every part of the scheme under the 1967 Act is reproduced in the modern scheme. The language, the organisation of the provision and the precise words used change slightly, but the material provisions are the same, save that there is no equivalent to section 28.6 of the 1967 Act, which previously excluded land that was part of a railway hereditament from what is now the section 64.2a, so section 64.2 deemed hereditament. So starting then, page 1 of my table, and the reason I've done this, I hope it's helpful, is otherwise we need to spend a lot of time flicking backwards and forwards through the bundles, and hopefully this way we can just stay on the 1967 Act itself, which is behind tab 10 of the authorities bundle. And the first relevant provision beginning at page 68 is section 28(1). And that provides that where the right to use any land, including various bits, for the purpose of exhibiting advertisements is let out or reserved to any other person, etc., that right shall be deemed for rating purposes to be a separate hereditament in the occupation of the person for the time being entitled to that right. And almost exactly the same language is to be found in section 64(1) and then 65(8) of the 1988 Act. So, my lords have looked at those extensively yesterday, so I'm going to ask you to turn them up again. But you have the first part of section 28(1) is now section 64(2), and the second part of section 28(1), which dealt with who's in occupation in the bottom left-hand box of that table, is now section 65(8). Right.
All comes from the section 56 of 1948.
All comes from section 56 of the 1948 Act. And then over the page, what was also in section 28 1967 Act, section 28(6), subsection 1, so that's the equivalent to what is now section 64(2), shall not apply to any right to use for the purpose of exhibiting advertisements any land forming part of railway or canal purposes within the meaning of section 32. So there's an express exclusion if the land in question is part of a railway or canal hereditament within the meaning of section railway or canal premises for the purpose of section 32, then the fact that any advertising rights, or any rights to use it for the purposes of displaying advertisements is let out will not create a separate hereditament. So then when you come to section 32, you don't have to think about whether those rights are let out to create a deemed hereditament under the statute. So then you have section 32, which essentially does what regulation 6 of the 2005 regulations now does. And part of the purpose, I confess, of preparing this table was to help me in my preparation to match that up and understand that. And you can see, if you trace it through, section 32(1) defined what was being talked about there. The section was to have effect with respect to premises which are occupied wholly or partly for non-rateable purposes of any of various boards, but including the British Railways Board. And just for completeness, I haven't put it in the table, but you see page 70 of the authorities bundle, section 32(2), section 32(3), that no railway canal premises which are or form part of premises occupied wholly for non-rateable purposes are liable to be rated or to be included in any valuation list or in any rate. And the remaining provisions of section 32, in particular, section 32(5) on page 71, provide that in lieu of the rates which would, apart from those provisions, be payable, an amount determined in accordance with a formula in the schedule to the Act is to be paid. So it's not that the old British Railways Board didn't have to pay any rates, or didn't have to pay anything equivalent to rates, but it didn't have to pay general rates under the General Rates Act. In the same way that Network Rail doesn't pay rates under the local rating, the local list provisions, the hereditament goes into the central list and it pays its rates to the Secretary of State. So section 32(1) defined what that overall hereditament was, or premises which are occupied wholly or partly for non-rateable purposes of the British Railways Board. And you see that then, first of all, in the 1989 regulations, the second column on page 2, part 4 of the schedule prescribed to the British Railways Board.
Sorry, can you say that again? The reference?
It's part 4 of the schedule to the 1989 regulations. And that's behind tab 11 of the authorities bundle, page 76. And it prescribed to the British Railways Board hereditaments other than accepted hereditaments that were used wholly or mainly for the purposes of the parts of the designated person's undertaking concerned with the carriage of goods by rail, etc., or for purposes ancillary to those purposes, which included the purpose of exhibiting advertisements. And as I've said, noted in the table, regulation 3.1b of those regulations provided that what was prescribed in the schedule, I'll have to look at it on page 73, equivalently to what are now, we had a discussion yesterday, the opening words of regulation 6. What was prescribed was each hereditament situated in England which on the day concerned is occupied or if unoccupied owned by that person.
If you're occupying a hereditament for the purpose of exhibiting advertisements, the hereditament is the physical space.
Yes.
It's not the right to advertise.
No.
You don't occupy a right for the purpose of exhibiting advertisements, do you?
That is the difficulty that the statutory scheme intervenes to address. So all the provisions we've looked at, the difficulties that there were in the earlier case law about does this use for advertising purposes meet the test of rateable occupation? Is it sufficient occupation?
The St Pancras.
St Pancras case, and issues such as if someone owns a hereditament but is only using it for the purpose of displaying an advert, is that occupation for the purposes of rating? All of that is now deemed all of that is dealt with by the statutory provisions.
Yes, but not by deeming it to be occupation, just simply deeming it to be a hereditament.
Well, in the deeming it to be a
It's
hereditament,
very straightforward. It goes direct to deeming it to be a hereditament.
Deeming it to be a hereditament and deeming it to be a hereditament in the occupation of the person who has the right. And in the case of deeming the occupier of the hereditament to be the person who has the right.
Exactly.
So there are 2 stages to the analysis. But the other relevant provision is the one that my Lord Justice Holgate asked about yesterday, section 65(8), I think. No, 6. Let's make sure I get the reference right. But section 65(8)(a). And again, is necessary precisely because of the point that my Lord Justice Nugee made about are you occupying by displaying an advertisement, or are you occupying the land, or whatever it is? It is deemed right to be treated as occupied by an otherwise unoccupied property is deemed occupied by a person who is permitting it to be used for advertising purposes. So you don't have to wrestle with the question of whether that amounts to occupation.
The hereditament is deemed as being occupied by that person. Is that right?
The hereditament, which already exists.
The advertising hereditament.
In 65(8)(a), it's just a hereditament, so you may have an empty shop and no one's using it as a shop, but the front of it is the owner of the premises has permitted it to be covered with adverts for which they're receiving income.
Yeah, but in 8A, it may not matter, but in 8A, the hereditament that's being talked about in the final line is the use for exhibition of advertisements, isn't it?
Yes.
It's
So
to be treated as occupied by the person permitting it to be so used.
Yes.
That's not the property itself. That's the advertising.
no, it's in that case, the hereditament, the empty hereditament, is not being occupied, but it is being used for the purposes of displaying advertisements.
The hereditament is the land.
Yes, the hereditament there is the land. Yes, not a separate right to display
not the
advert.
advertising.
Yes.
right.
Exactly.
So as you say, if you have an empty shop,
Yes.
you own it,
Mhm.
and it's not otherwise being occupied,
Mhm.
but you let people put adverts on it,
Yes.
and you're deemed to occupy the land
Yes.
if section 64(2) doesn't apply.
Yes.
But if you let out the
Right. Yes.
right in section 64(2), then you're not within 8A, you
Yes.
don't get rated under 8A. Instead, the advertising contractor
That's rated.
gets rated for the
Yes.
deemed hereditament, which is
Yes.
the advertising right.
Yes.
So they're mutually exclusive regimes. So
Yes.
either there's a letting out in 64(2) or there isn't, and
Yes.
then they get into 8A.
Yes. So a person who is using their own property, which is otherwise a hereditament, for the purposes of advertising, doesn't engage 64(2). It's only if they let out that right, and that is then it's not then exercised, cannot then be exercised by the person who owns or occupies the hereditament because they've let it out. So then, returning to the table, as I say, section 32(1 defined what we were talking about as the premises occupied wholly or partly for the British Railways Board, and you see that traced through the 1989 regulations. Then I haven't dealt with the 1994 regulations, it's amended the 1989 regulations and were only enforced for 6 months. I've just gone straight to the May 1994 regulations, which are behind Authorities Bundle tab 13. And by 1994 you had privatisation, you had the British Railways Board and you had rail track. So the provision becomes, on the page, somewhat more convoluted, but essentially the same provision. But if you have something that is occupied or if unoccupied owned by either the British Railways Board or rail track, or is let or licensed by them, and this is the new provision reflecting privatisation and the various different railway operators that are now involved, to a licence exempt operator or licence holder, wholly or mainly for the purpose of providing railway services, or for purposes ancillary to those services, including the purpose of exhibiting advertisements. That's the cumulo hereditament that goes into the central list. And it's in more or less the same terms in Regulation 7.1 of the 2000 regulations and tab 14 of the Authorities Bundle. But in that regulation, you'll see towards the bottom by small Roman I that the term used wholly or mainly for railway purposes finds its way into this statutory language for the first time, and railway purposes is then separately defined. Dealt with that on the next page, and I'll come to it. But it's defined in the same terms as it had previously been defined, or as had previously been used in the 1989 and 1994 regulations. That is the wholly mainly for the purpose of providing railway services or purposes ancillary to those services, including the purpose of exhibiting advertisements. And then you have the current Regulation 6, which I think since the start of these proceedings has been amended to include HS1. Anything turns on matter, we need to worry about it. Where Network Rail occupies, it was unoccupied, owns any hereditament, etc. Then subject to conditions which include that the hereditament is used wholly or mainly for railway purposes and is not an accepted hereditament. It will be part of the single assessment in the central rating list. So there are two concepts which again you can trace through from the 1967 Act right through to the present regulations, and they're dealt with over the page on page 3 of this table: the concept of the accepted hereditament and the concept of railway purposes. So taking the accepted hereditament first, under the 1967 Act, section 32(2), premises were not to be treated as railway or canal premises for the purposes of that section if there are premises of any of various descriptions which included premises so let out as to be capable of separate assessment. And you see then in each set of regulations from 1989 through to the present day that in each case those words are reproduced, save that, and I'll come to this shortly, the term premises becomes premises or rights. What I say is, and I will develop this, is that premises or rights reflects the fact that previously it could only have been premises, because rights that were let out on the railway hereditament would not be deemed hereditaments under section 28 because of section 28(6). When section 28(6) goes, so does that. So maybe it may now be premises or rights that are let out so as to be capable of separate assessment. And then finally, railway purposes. As I say, the term itself doesn't appear until the 2000 regulations, but the concept of non-rateable purposes, the use of the premises, and that goes back to section 32(1), non-rateable purposes of the British Railways Board. Section 32(7) expanded on what were those non-rateable purposes. Section 32(6) is the main, on page 71 of the authorities bundle, was the primary definition. It was all parts of the board's undertaking which are concerned with the carriage of goods or passengers by rail or inland waterway, etc. But then there was subsection 7(c) that included in those purposes, or provided that if railway premises were occupied by a transport board partly for non-rateable purposes and partly for the purpose of using them by a transport board for exhibiting advertisements, that last mentioned purpose, exhibiting advertisement, was also deemed to be a non-rateable purpose. So you have the core definition of what is the purpose of the railway, and then you have deeming of exhibiting of advertisements included within that, and that is again carried through in each set of regulations. So in 1989, the hereditaments that were prescribed under the schedule were those that were used wholly or mainly for the purposes of the parts of the designated person's undertaking concerned with carriage of goods or passengers by rail, or purposes ancillary to those purposes, including the purpose of exhibiting advertisements. Essentially the same wording in 1994. And then in 2000 and 2005, in each case, part of the condition for being within this remit of hereditament is that the hereditament concerned is used wholly or mainly for railway purposes, and railway purposes in each case is separately defined, and these are the final boxes on page 3. In in each case defined as the purpose of providing railway services or purposes ancillary to those purposes, including the purposes of exhibiting advertisements. So all the way through from the 1967 Act to now, if the railway operator, however it's described, the board, rail, track, network rail, is using its land to exhibit adverts, that can come within the definition of railway purposes. But in none of those cases does it apply to the deemed statutory hereditament if advertising rights are let out. The difference between the scheme under the 1967 Act and the scheme under the 1988 Act is that the deemed hereditament, when the advertising rights are let out, can exist on the railways.
And that's because section 28(6).
Because there's no equivalent to section 28(6).
So can you say that again? The deemed hereditament by
Where
virtue
now-
of section 64
64(2),
2,
yes,
yeah.
can exist in relation to railway land that forms part of, otherwise forms part of the railway hereditament.
That's deliberate change in 1988. And we know it's deliberate because when you look at the regulations, the words premises or rights
Exactly that.
added in. So it's not just an oversight, but a drafting infelicity. It's a conscious decision not to reproduce 28(6). And the consequence of that is you put in the words premises or rights.
Yes.
As opposed to just premises.
Yes.
And you didn't need to have any specific confirmation that railway purposes could include the purpose of exhibiting advertisements before the 1988 Act.
Well-
because of this effective section 28(6). Is that
No, you did, and you did have it, so to be absolutely clear, in section 32(7)(c). So this is the first column of the table, the last box.
For example, the Railways Board might be doing its own advertising.
It might be, yes. But there's also, and I'll
Without letting out to a third party.
exactly that. And that wouldn't, and the purpose of that provision is that that would
yes, I see.
it brings
Sorry.
land that the railway or it ensures that land that the railway board is using for that purpose is included within the central hereditament, even though it's not being used for what would otherwise be considered railway purposes. So one of my learned friends' points yesterday was that the purpose of all of this is amalgamation and simplification, and that's right in the sense that Network Rail or its predecessors only have one rates bill. So Network Rail doesn't have one rates bill for all the parts of its land that aren't being used for advertising, and another series of separate rates bills where it chooses to advertise. But the point there is Network Rail is an occupation of all of those.
It's still a bit odd, isn't it? Because the rights which are referred to in the definition of accepted hereditament are advertising rights. But if Network Rail has let out the rights so as to give rise to deemed hereditament, it's not itself going to be an occupation of them. So why do you need to say this?
Well, that's a very good question, and one that has been grappled with by this court, and is where I was going to go next. It's the case of case. Say that carefully. It is in the authorities bundle behind tab 20. Now, this is a case that was decided in this court, well, heard in this court in December 1971, decided in March 1972. And so the 1967 Act is in force, but it's considering chiefly Section 86 of the 1948 Act, but which,
Is this the
in the
social
same
club?
terms. This is the social club, yes. And you'll see on page 197 of the authorities bundle, still in the head note of what was decided in this case, the first paragraph that starts on that page, the indentation, little letter B, the words "so let out as to be capable of separate assessment" in the proviso, and the proviso there is the accepted hereditament equivalent provision, was strictly, I hesitate because I always get the pronunciation of this word wrong, surplusage. For letting out involved that the board had permitted some other body to occupy the property for some purpose other than that of the board, with the consequence that as soon as a hereditament, which would otherwise be a railway hereditament, was so let out, it ceased to be a railway hereditament at all, and Section 86(1) could not operate in respect of it.
It's in relation to premises.
That's in relation to premises,
but
because
logically it's the same point.
Yes.
Once you've let it to someone else,
Yes.
you're no longer in occupation.
No.
Therefore, you don't satisfy, you don't go in the central list because it's not a railway hereditament.
Exactly. And that's what why Lord Justice Buckley, you asked the Court of Appeal to describe it as surplusage.
And same applies to the words premises or rights under the current regime.
It's exactly the same part of the provision. That's why partly why the table is helpful to trace it through. This is dealing with words that carry through into Regulation 6.4 with the addition of the words "all rights." I accept that. Just to make that good, you see on page 202 of the authorities bundle, it's page 104 of the report. What's being considered here is Section 86 of the 1948 Act, which defines railway hereditament as a hereditament occupied for the purposes, etc. And then just above the second hole punch, there is the following proviso to Section 86(1), provided that no premises occupied as a dwelling house, hotel or place of public refreshment, or so let out to be capable of separate assessment, shall be deemed to be or to form part of a railway hereditament. And that is, I say, the forerunner, clearly, my submission, the forerunner to this concept of accepted hereditament that you see now in the 2005 regulations and all the way through the sets of regulations that are made under the 1988 Act. Now, you were shown yesterday by my own friend Mr Polinsky what was said on page 213 of the authorities bundle. That's 115 of the report in the judgment of Lord Justice Buckley. And he started at the top of that page, the difficulty arises from the use of the somewhat odd expression "let out," and there being little authority on its meaning. I say it's clear when you read that, all of that in context, and in particular at the bottom of page 115, that what's being talked about is letting out for the purposes of the provision. This is going back to my first one, well, in case, just to deal with it. But at the bottom of page 115 on to 116, it's clear that what's being talked about is the particular combination of words "let out so as to be capable of separate assessment." It's what Lord Justice Buckley says at the top of page 116 of the report, 214 of the authorities bundle. that only in these circumstances, and by these circumstances it means that the ratepayers, previous sentence, who but for the letting out would be an occupation of the hereditament, have permitted some other body to occupy it for purposes other than purposes of the ratepayers. Only in these circumstances, it seems to me, could the letting out result in the hereditament being capable of separate assessment. And he says then, the point that's picked up in the head note, the first paragraph that starts on that page, this leads me to the conclusion that the words also let out as to be capable of separate assessment are strictly surplusage. Their inclusion is perhaps precautionary to draw attention to the fact that the hereditament in the ownership of the ratepayers, but in the occupation of someone else, not for the purposes of the ratepayers, but for the independent purpose of the occupier, is not a railway hereditament, even if the occupier's purpose may benefit the ratepayer or in some way subserve some purpose or purposes of the ratepayer's own undertaking. But he's making precisely the point my Lord Justice Nugee makes, that if something is already so let out as to be capable of separate assessment, you don't then need, it doesn't come within the main provision, and you don't then need the exception at the end. But it's there, perhaps says precautionary, to remind you.
Maybe it was inherited from the 1930 Act, where
Maybe.
the words railway hereditament are defined with a similar proviso.
That may be, and it may be that we could, somewhat surprisingly, have done more by way of historical research to assist this court, but there is decision of this court.
And what's happening is in the 1930s, you were dealing with private railway companies, weren't you?
Yes.
But the 1930 Act came along so as to amalgamate. The legislation is created then. When you get to the 1967 Act, possibly even before, I wouldn't like to say when, the railway companies, the nationalised railway companies, were not rateable in respect of their main premises, but they paid rates in lieu.
Yes.
It's what that, you know,
It's that.
not a question of central rating, of course.
No.
That doesn't come along properly so called as a term of art until the 1988 Act.
Exactly that. But it, to some extent, builds on and incorporates that.
What you're saying is, for the sake of avoidance of doubt, this language, which was originally the 1930 Act, is preserved.
That's what the Court of Appeal thought in case, certainly.
Those are the words which Lord Wright was considering in Southern,
Yes.
which was on the construction of the 1930 Act, which was a special act for railways.
Did the 1930 Act cover canals as well?
I'm not going to answer off the top of my head. It's called the Railways Valuation for Rating Act, so one suspects not, but you stand to be corrected. I imagine so, maybe somewhere a canals valuation for rating act.
Look at subsection 13A. Canals occupied by the railway company.
So my learned junior makes
Wasn't
the very good point that actually the railways did incorporate canals. So you can see that on in the 1930 Act, which is behind tab 6.
Thank you. Well, if they carried on a canal.
Yes, if they carried on a canal, but there is that historic linkage between the canals and railways, which may not seem so obvious in the 21st century, but makes more sense when one perhaps thinks about the history there. course, the way the 1930 Act works, you see here, is that the railway hereditament is defined as any hereditament occupied for the purposes of the undertaking of a railway company. So, in that sense, Southern Railway proceeds on the basis that the W.H. Smith kiosks, for example, are occupied for the purposes of a railway company, otherwise you wouldn't get to the proviso.
Well, you can see that in that having facilities for travellers to
Exactly.
buy books might encourage them to.
Yes. Yes, but in this context it makes sense because the starting point isn't necessarily occupation in the sense of physical occupation by the railway company, whereas from the 1967 Act and second 1988 Act, you only get as far as the proviso, so termed the accepted hereditaments, if you've started with hereditaments occupied by the railway operator. So that's why I say in case this court recognised that it was properly surplusage, properly so called. And just my final point on that, because my learned friend relies on the fact, of course, that Regulation 64C refers to premises or rights so let out as to be capable of separate assessment, and points quite rightly to the difference between that and Section 64(2), which just refers to rights being let out. But I say consistently with it being surplusage point, you are talking when you get to 64C about hereditaments that are not in the occupation of the Network Rail, the railway operator. And as a matter of logic, a hereditament that is created by 64(2), deemed to be in the occupation of the advertising contractor by Section 65(8), is now so let out as to be capable of separate assessment. That is factually correct, if my case is right. Describing it as such, it's still surplusage. Now, I should say, be absolutely candid, that this is not the same, the analysis that I've just presented to the court, as the analysis in our skirting argument at paragraph 85. This is my, I hope, refined understanding of the arguments following yesterday's hearing and the what I found to be a helpful process of working through the provisions and preparing that table. But I say when you look at it and look at what each of the provisions are doing, Regulation 64C is a direct statutory successor to the proviso that was under consideration in case.
Just for the avoidance of doubt, I want to reflect on these submissions in due course. If we go back to Regulation 6,
Yes.
tab 3 of the authorities bundle, accepting hereditament. And I'm just comparing it, for example,
So it's
with
6.2c. I've been saying 6.4, haven't I? Oh no, I think it's
yes,
that's 6.4c. That's fine.
yes. I'm just comparing 6.4c with 6.4 with 32.2.
Yes.
A is similar in scope and function. Comparing it to page 70.
Yes.
B, premises used wholly or mainly as office premises when they're not situated on operational land, and that is similar. In function to B.
Yes.
I mean, obviously the details change because the structure, the
Yes.
way in which the industry is organised has changed. And C, we start with premises or rights so let us to be capable of separate assessment,
Yes.
other than those falling within 1B or 2B,
Yes.
which brings in
Those two.
British Transport Police, etc.
Yes.
So what is surplusage on your submission in C now?
All of it.
Because going back to 6.1b, that's explicit and it's covered. So really, even when that's, you're saying even when that's brought into C, it's only confirmatory.
It's making clear that the regulation does what it intends to do by incorporating that the licence holder and the licence exempt operators are treated for these purposes as part of the railway. So, my lords, those were my points on the legislative history. Moving on then to the final section of my submissions, I'm conscious I've taken slightly longer than I said I would, but I think this section hopefully will be relatively swift. 2 points plus ground 4. So the first point to address is my learned friend's submission that the 1988 Act and the 1989 regulations need to be read as a whole and sense made of them. Now, firstly, I say that doesn't actually assist him. I've shown you how you read them all together and how that makes perfect sense in the light of legislative history and leads to the result for which I argue. But just on that point, it is also something that the court should note that the 1989 regulations, first set of regulations under the 1988 Act, were enacted in December 1989. So that's, and you can see that on the first page of them behind tab 11 of the authorities bundle, and that is almost 18 months after the 1988 Act comes into force. So I don't propose to go to the detail of the cases on when secondary legislation can properly be used as an aid to interpretation of the primary. We've included at tab 36 the learning that's in Benyon on that subject, which really summarises the cases that my learned friend has put in. I don't think there's any issue between us on the principles here. But first to say there's no no ambiguity here that you need to look to the regulation. I don't confess necessarily quite follow exactly how the point has been put, but insofar as it's a point about interpretation of the primary legislation, I say there is no relevant ambiguity in the primary legislation that one needs to look to the secondary or any other source to resolve. But I do also say this isn't a case of the type where the draft regulations were before Parliament at the same time as the Act. And they cast light on the interpretation of the Act. In that sense, these are regulations made after the Act came into force, and could have made different provision to that which they do, consistently with the enabling provisions. So I said that point doesn't go anywhere. And the other point my learned friend made relating to the previous practice and what was said by Lord Carnwath in the Iceland and Berry case, about consistency in the way things have been operated. It was a feature of the Iceland and Berry case, and this comes out in the passage that I referred you to on page 354, tab 25 of the Authorities Bundle, paragraph 36. That Mr Morshead, who was counsel for the valuation officer in that case, wasn't able to explain why until as recently as 2009 the valuation officer had taken a different view. Now, in this case, that is explained in the valuation officer's evidence. It's in the statement report of Mr List, which is in the supplementary bundle at tab 11, on page 179. And he says essentially that it wasn't previously thought that the advertising rights had been let out.
I didn't quite hear that.
It wasn't previously thought the advertising rights had been let out. He's responding here to the National Rail's reliance on the rating circular published in 2000, which said at the time of writing it's understood that no advertising rights have been let out, although it does identify that the position had become less clear. What happened in this case, as Mr List explains at paragraph 16 on page 179, is that the billing authorities for these two stations requested that the valuation officer bring one hereditament in each into assessment, which is what has been done ultimately. But that was done, as Mr List says, after consideration of the arguments and the legal advice. And it was at that stage that the valuation officer first saw the relevant agreement. So, to an extent, of course, I accept this as a fact-sensitive inquiry. There will be cases, as posited by my Lord or Justice Holgate in argument yesterday, where there is a management agreement rather than the letting out of the right. But having seen the agreements and taken advice, the valuation officer formed the view that in this case, the agreements in the terms in which they currently apply and currently applied at the relevant date did amount to a letting out. It's not a wholesale approach, it's a better understanding of change of approach, it's a better understanding of the facts.
I understand what the position is.
And one way of reading that is you've got in mind, or or the person who wrote the advice had in mind the regulations, which turn out to be surplusage. But it doesn't appear, unless there's something else in the document, to be a commentary on 64.2.
It's not a wholesale change of the valuation officer's approach to a particular provision. It is an application of that provision to facts, facts that were had not previously been as fully investigated as they have now. Not least in the Upper Tribunal and the First Tier Tribunal.
I mean, Iceland is all plant and machinery.
Yes.
Horrid subject.
Horrid.
And the report on Mr Derek Wood and so on. So it's
yes.
a very convoluted area where you're actually construing regulations which are very practical in their, seemingly, in their application. It's almost like construing regulations in a scientific or technical context. We're basically construing primary legislation here.
Exactly that. Exactly that. So my last task then is to cover ground 4, I've called it my note, the chaos and convenience point. And the first point under this round, is one I've already made, is that there is no ambiguity here in legislation that requires resolution. It is a statutory scheme, and I say means what it says on its face. And not one where there are two different competing interpretations where it's necessary then to rely on concepts such as statutory purpose or administrative convenience to choose between two potential readings. And I also say that there's no evidence in this case of chaos or complexity, excessive complexity that would be caused on the valuation officer's interpretation.
You mean there's no evidence? There was no evidence before the Upper Tribunal.
And there's evidence that it's a change. There's evidence that it's a change. But my own friend said yesterday that we're only here because of the work and the inconvenience that would be involved for his clients, for JCD, and he says altruistically also for the valuation officer. But at most, what's required of National Rail JCDecaux is to keep the valuation officer updated on changes to the schedule, which sites are let out and which sites aren't. Now that's obviously something that's being done, as in the schedule's being updated. There's no evidence of how this would be such a terrible administrative burden.
Do you accept what Mr Klinsky described as atomisation, that each separate site has to be separately listed?
Yes, that is the, I mean, it is that. That is the case with all other kinds of advertising sites on other types of property, subject to similar types of agreement. So bus stops, for example.
You know, I was wondering about
That's the
bus
position.
shelters and so on.
Those are all in the list.
Separate.
There's no central.
Yes. And supermarkets, another example. So what's being argued for here is special treatment for the railways.
I mean, you take London, for example. I asked to come across a sort of omnibus agreement between whoever it was, London Underground or now TfL, and an advertising company.
Like JCDecaux.
Like, yes, there was such a case, of course, forbid. you can go to an omnibus agreement, and that will identify for you the individual locations.
As this one does. And you have, I think you were showing that just for the avoidance of doubt in the confidential bundle, you have at tab 3 the unredacted 2010 agreement and the
Sorry, can
schedule.
you give the reference again?
It's the confidential bundle,
Yeah.
tab 3. And you have the schedule of sites from pages 52 through to 219. They're identifiable, and they have to be identifiable for Network Rail and JC Deco's commercial purposes. So they know where JC Deco can advertise. It's advertising.
They'll have to be individually valued.
And that is, it sounds flippant, that is quite literally my client's job. I'm not saying my client would.
Imagine when the central listing approach is taken, the profits sorry, the receipts and expenditure method.
Yes, it would be less work.
It's less work because you go to the accounts and then you adjust the accounts so as to relate to the rateable property, both revenues and expenses, but you don't have to drill down to look at individual advertising sites.
My client is.
But you would say that's no different from doing this elsewhere outside a railway heritage.
I think the valuation officer is
Individual advertising rights.
the valuation officer is required to value hereditaments for the purpose of the local list, whether big or small. The valuation officer is required to value, has been required to value numerous telecommunications hereditaments, and small shows it. The valuation officer is required, following Cardtronics, to consider very carefully in lots of individual cases the relationship between a host and a potential separate occupier. So all of these things might be said to create more work for the valuation officer. That's not a reason for the valuation officer to seek to interpret the subject in a way that,
and for the other parties.
in some cases, yes. But in this case, in terms of other than the valuation officer's valuation, the administrative chaos, sort of keeping matters up to date, is of course relatively easily done electronically. That's how the agreement is. I don't think we have evidence of how frequently sites come in or out. But it's not suggested it's on a daily basis in such, even if it was, as my lord noticed on a number of occasions, it is a tax subject to a daily liability. But there is, so I say that there isn't evidence of such difficulty of operation as to require this court to bend the words of the statute to look for some other way of doing it. So the valuation officer is required to value numerous sites, will be required to value some more sites if there are more sites in the list, that's right. Valuation officer isn't, certainly in this court, complaining about that, whatever the individuals involved may say in private. But I say the atomisation point is overstated because these are only one set of advertisements under one agreement on one type of hereditament, and what's being asked for is different treatment of those to all of the other advertising sites around the country on other types of hereditament that do appear separately in the local list. My then friend's also made some points that don't really feature in the evidence about other parts of the rating scheme, the position in cinemas, the position with rights to put up signs in shopping centres, for example. Now, what this court doesn't have is any evidence of what agreements there are in those cases and whether there's anything that might be characterised as a letting out of the right to display advertisements, which is what section 64.2 covers. Now, whether a cinema operator permitting film companies to advertise in connection with the films that are being shown at the cinema is letting out the right to display advertisements at the cinema seems to me to be something of a in that particular context, without an advertising contractor such as JC&Co stepping into the middle, as is in this case, and having the right to deal with the advertising space, is a wholly different situation. And it's not one that's before this court now. But I don't, because perhaps unlike my own friend, I have not seen any of these agreements. I don't make any submission to the court about whether they would or they wouldn't be separate lettings out. But it's certainly not something that this court has to be concerned about. It's not an agreement this court has seen. Similarly, there is some distance between the right to exploit, manage, promote and take the income from advertising space, such as is let to JC&Co in this case, and the right of a shopkeeper or franchise operator to put up a sign saying, this is what I'm selling. We're concerned here with section 64(2) and a right to display advertisements. And on any view, we say, and that's what my own friend Mr Flanagan's going to deal with next, such a right has been let to JC&Co. One final point, if I may, because I'm conscious I haven't dealt with any of the case law in the Cardtronics line on paramountcy separate. That's because I say we don't need to. But I do just want to finally show my lords a very small part of Cardtronics and why I say it supports, on proper analysis, it supports my case. Cardtronics is behind tab 27 of the authorities bundle. And I'm sure my lords are familiar with the background to it. It concerned ATM sites at retail and other premises, where the valuation officer's case was that by installing an ATM on a particular site, the ATM operator had taken rateable occupation of that site and thereby created a separate hereditament. The history of the litigation is that the valuation officer was fully successful in front of the Valuation Tribunal, and progressively less so up to the Supreme Court, where the ATM operators and host superstores were wholly successful. And in the course of that, the arguments that were made, as I've said, depended on whether there was separate rateable occupation of the ATM sites. The Supreme Court rightly treated it as two separate questions: whether the ATM sites were capable of being hereditaments, and if they were, whether the ATM operators were in occupation of them. It decided the former point in favour of the valuation officer, in the sense that these were capable of being the subject of a separate entry in the rating list, and you see that on page 405 of the authorities bundle at the very end of the first paragraph of the head note. But the main 405 first paragraph of the head note, so just above where it says Woolway. Each of the ATM sites, except the movable ATM site, was capable of being the subject of a separate entry in the rating list. But then the main issue, second part of the head note, concerned where actual occupation of a site was shared between two occupiers, one of which was the owner of the site, the question of which was in rateable occupation, etc., felt to be considered, and that's where you then have the consideration of Southern Railway and all the case law after that on paramountcy and control. I just wanted to show, my lords, firstly, paragraphs 14 and 15 on page 410, 410, the authorities bundle. Lord Carmouth there addressed the case of Holywell Union, where the concepts of paramount and subordinate occupation first really emerge, and then notes they were taken a stage further in Southern Railway, and he sets out there an extract from Lord Wright's speech.
What does he mean when he says taking a stage further? What was the further?
They were
stage?
developed.
Sorry?
They were developed. So he's talking. Yes.
Yes, but
What was the development? There were,
is it the
they were
landlord
fleshed out,
control?
yes.
Is it the landlord control
Yes.
principle? Yeah.
Yes.
Okay. Thank you. Sorry.
So what I wanted to draw to my Lord's attention is firstly the extract from Lord Wright's speech. The question is whether the premises in question have been so carved out, railway hereditament, etc. But the important words are at the end. Whether they have, though let out, been so let out as still to leave them in the occupation of the railway company. So it's firstly recognised that something may be let out in a way that nonetheless leaves the railway company in separate occupation. And I say, when my learned friend says, well, let out always means let out so as to be capable of separate assessment, I say, well, no, that distinction is expressly drawn there by Lord Wright and Southern Railway. But I also want to draw my Lord's attention to the final words of paragraph 15 in Lord Carmouth's speech. That in that context, as I've described it, the question of whether, by placing an ATM on the site, a separate rateable occupation, separate hereditament has been created. For these purposes, although it may be convenient for analysis to separate the issues of hereditament and occupation, they are in truth linked. That is, in my submission, an apt description of the entire line of case law that my learned friend seeks to rely on, the SO case through to this case, that when the question is whether a separate hereditament has been created through occupation, then of course those cases are relevant. And of course those cases are precisely on point. They are not concerned with the statutory deeming of a hereditament under section 64.2, which is not linked to the concept of occupation, because the concept of occupation, the identification of the occupier is dealt with separately in section 65.8. So I say all of this is about the undoubted complexities that can arise when considering who is in rateable occupation. And I come back to the point that the statutory intervention here was for the purpose of answering that question in relation to the use of land for the display of advertisements, rather than requiring recourse to all of that case law. I say that ultimately, if Parliament had wanted the result that my learned friend contends for, it could have included an equivalent to section 28.6 in the 1988 Act, could have provided in the regulations that the separate hereditaments otherwise created by section 64.2 should be included in the cumulo railway hereditament. And I say this is straightforward reading of the statutory provisions that I started with yesterday. There's a letting out of the right to display adverts. Network Rail no longer has the right to display adverts. Section 64.2 is engaged. JCD is in occupation. And Regulation 6 has no application to hereditaments that are already deemed to be in the occupation of JCD. Clearly right on the face of the statutory language, and nothing in the arguments presented by the appellant can displace that very clear language.
So just coming back to the distinction between occupation and hereditament, if we go back to 64.2, what we're concerned with is a right to use land. right to say that it's the exercise of that right rather than the right itself as a result of reversal of imperial tobacco in 9.6 that matters, or is it simply the right that matters?
I might tell in this case it makes
Say matters constitutes the hereditament. Well, is it the use of the land for that purpose which constitutes the hereditament, or is it the right to use the land?
it's the right that constitute the right to use the land constitutes the hereditament. The question of I think the other point's a question of valuation. May I just turn my back for a moment?
Manifests itself. Anyway, it manifests itself.
Okay. So it will be valued at the point when it starts manifesting itself. So when it's exercised.
But it's the right which is the hereditament, whether exercised or not.
Yes.
Well, if it's the right that is rateable by virtue of this deeming provision, why is it only valued when you exercise it? The right is valuable in itself. I mean, what I'm not sure about is the statutory reversal of imperial tobacco.
Yes, and whether that counts.
Subsection 2, which was pointed out yesterday, which seems to justify this exercise threshold. How, to what extent has that been carried through to even this?
Well, I confess because it's not been an issue in this case. I've not satisfied myself with the answer to that. I'm just going to check whether
I'm
or
not
not
even sure we've seen it in the 67 Act, let alone the 88 Act. So I may have missed something. Because this argument seems to hang on subsection 2 of the 61 Act, section 9, wasn't it?
Is it section 9.6 of the 55 Act?
It was in the 67 Act. We looked at this. It's 28.2.
28.2, sorry.
Which reproduces the effect of 61.
Thank you.
But I don't think your very helpful table tells us what's happened
to 28.2.
It may be reproduced somewhere else, or it may have gone.
Yes, there it is.
Yes.
Page 69.
What I can say is that the valuation officer doesn't value advertising until it is advertising rights until they are exercised. What the precise statutory basis for that is, I will perhaps try and investigate during my learned junior's submissions on ground 3, and if I can get to the bottom of it, assist the court with that after that, if that's convenient.
They're just coming back to section 64(2 then. If it's the exercise of the right rather than the right which constitutes the hereditament, it's still a use of land rather than an occupation of land.
Yes.
And that's why you draw a distinction between occupation and use for the purposes of the advertising.
I say that the question of whether the use of land for the purpose of exhibiting advertisements is or is not rateable occupation was considered so difficult that Parliament had to intervene and deem that now, so I was just thinking about the complications of the early legislation, but Parliament had to intervene to deem who would be the rateable occupier in relation to land that was used for that purpose.
Use is not the same as occupation.
Yes.
And I was coming into this through
Yes.
the passage you identified in Lord Carnwath's
Yes.
speech in Cardtronics, that hereditaments and occupation.
Yes. That use is not the same as occupation.
Are
Exactly that.
exactly the same question, but
No, exactly
I
that.
understand that in relation to land, where hereditament is defined by reference to occupation.
Yes.
But it's difficult to see that they're not separate questions absent deeming.
Yes. Well,
Hereditament we're concerned with is a use as opposed to an occupation of land.
exactly that. So come back to the example of the empty shop and the advertisements placed on it. It is, if left to the general law of rating, that may well not be an occupation of the shop, but we have section 64(8)(a) to tell us that it is treated as an occupation of the shop regardless. In the section 64(2) case, the right to use land for the purpose of exhibiting advertisements is part of the bundle of rights that the owner or occupier of the land may have, but the exercise of that by itself may well not constitute rateable occupation of any part of the land. But if that right is let out separately to a third party, a hereditament is deemed to be created, even though on the ordinary law of rating it may well not. So it's a simplification provision. This is difficult. The courts were struggling with it. That's exactly what Lord Denning said.
But it might be a little bit more than that.
More than that. Guilty of
Lord Karl
simplification myself.
helpfully reminded everyone of the importance of the Holliwell case, which was relatively straightforward and clear. I mean, we're dealing with something in the nature of an easement, incorporeal right, not capable ordinarily in itself of occupation. Holliwell says that if you exercise such a right in such a way as to occupy land with a sufficient degree of permanence, you may create a rateable hereditament. So one way of understanding what's been going on with these specific provisions for advertising rights is that they make it unnecessary to go to carry out that inquiry.
Exactly that.
You don't have to apply the Holliwell test.
Yes.
Without going through the question as to whether or not there is occupation through the exercise of the right, it is rateable, full stop.
Yes, my law puts it much better than I have. But that is essentially my case.
Indeed, but consistent with that analysis, Parliament has gone on to say that the person entitled to the right is deemed to be the occupier when you're applying the occupied business rates provisions.
Yes, exactly that.
I got it?
Yes, exactly that, my lord. That is my case.
Can I try and make sure I've understood your case in relation to a different way in which it was put in argument, Mr Kalinsky? If you look back at what Lord Wright said the question was, which you showed us in paragraph 15 of the contract, when dealing with, it's page 410 of the bundle. The question is whether the premises, so he's dealing with actual physical land, whether they've been carved out so as to be capable of separate assessment, or whether, although let out, they've been let out so as to still leave them in the occupation of the Rurikhan. If I've understood your case correctly, in the case of advertising rights, you never get to that question, because once you've let it out, it is a separate hereditament in the occupation of the advertising contractor, so you never have competing occupiers of that right.
Exactly.
So the paramountcy question and the control question and so on don't really come into that.
Yes.
The real question is, have you let it out?
Yes.
And in a sense, when you go back to the language of accepted hereditament, rights let out so as to be capable of separate assessment, as soon as you have let out an advertising right, it not only is capable of separate assessment, it is to be separately assessed.
Exactly that.
So it's the same question.
Yes.
It just goes back to, have you let it out?
Yes.
That's your case.
That's my case. Unless I can insist, my lords, any further, and I will look at that point about when the hereditament comes into existence and starts to be valued. I propose to hand over to Elena Junior to deal with ground 3.
So, my Lords, so I'm going to simply deal with ground 3 and the agreement. And in overview on this ground, we say that the Upper Tribunal were correct that separate hereditaments arose in respect of the Victoria and Liverpool Street sites because Network Rail had parted with the right to advertise under the 2010 agreement. And that is enough for a separate advertising hereditament to arise on a proper interpretation of section 64.2. But even if you did apply Mr Kalinsky's approach of paramountcy or something analogous to it, which the Upper Tribunal effectively did in the alternative at paragraph 61 and 62, you get to the same result on the facts. So if I could turn to the 2010 agreement to make that submission good, in the confidential bundle, at tab 3, starting at page 19, where you have at 3.1, as the UT called it, the principal operative provision, clause 3.1, the grant of an exclusive right to maintain, manage, promote and exploit the sale of advertising space. And that is expressly subject to the provisions of the agreement, which need to be looked at, of course. But that grant, I say, is on its face squarely within the plain meaning of section 64.2, in that Network Rail has given away a valuable right to advertise in return for significant consideration, and JCD has acquired a substantive right which it can assert against Network Rail. The language of concession, I say, is important. You have it there in the paragraph, clause 3.1, the heading, scope of the concession, and also on the title page of the agreement. It is a concession agreement. It is not an agency or management agreement, so-called, which might indicate that JCD was acting as a managing agent or something of that sort. And obviously how the parties have described their agreement is not determinative, but I say it is relevant. And so that's the principal provision. And then the payment provisions I look at next. So you get partly within clause 3.1, which refers to the signing on fee. And you have that specified, the quantum of that, earlier in the definitions. And then you also have the other minimum payment and profit share arrangements. But in short, I say that paying a significant sum for the right to be able to do something is also the obverse of a management or agency agreement. JCD are paying to get a right. They are not being paid to provide a service. Then, as to the more detailed payment provisions, we've looked at them in clause 8, which starts at page 25. I only make the observation that the revenue share that you see there on page 26 of the bundle, and it's also in the witness statements, that the lion's share goes to Network Rail, but that's simply a matter of commercial bargaining and negotiation. It doesn't affect the fact that there has been a parting of the right to use the land for advertising. And more generally, I say that the arrangement of a minimum payment and profit share is entirely akin to a rent where you might have a fixed sum and a turnover rent on top, familiar from commercial leases. So nothing in that payment arrangement which is inconsistent with the right being let out. The next part of the agreement I just want to touch on is clause 18, which appears at page 34, which is about Network Rail's advertising. And Mr Kalinsky said that he didn't place much reliance on this. But I say it is illustrative or indicative of what's going on, clause 18.1, on the basis that JCD has to use reasonable endeavours to make available to Network Rail advertising space of the amount set out there. You can see the amount, and you can.
This is clause
18.1. Sorry.
Oh, sorry.
You have the sum set out there, and if the court wanted to, the court could obviously compare it to the scale of the minimum payment and the revenue that's identified or evidenced elsewhere in the bundle. But therefore it's a retention of a fairly limited amount of advertising, and it's only reasonable endeavours as well. But even if it was a bigger retention of a right to advertise, it is still consistent with, and indeed emphasises that, the right to advertise has otherwise been given away. Network Rail can no longer advertise other than to the extent that clause 18 allows them. And to the extent that the retention of some right to advertise under clause 18 is value significant, that will no doubt be reflected in the price which JCD are willing to pay for the right which they get. It might be calibrated accordingly, but the right still, the JC still get a substantive right. So that's clause 18, which is in one way in which the right granted to JCD has some limitations on it. Then, can I then go to back to clause 4, on which significant reliance is placed on by the appellant, starting at page 20 of the bundle.
How does that work from a valuation point of view? We came with Miss Ward the position where advertising rights may be let out for 1 day a week, and they are exclusively let out for that day of the week, and they can be valued and rated on the basis of that use on the Monday of each week, in our example. But if the sharing of the right to use facilities for advertising is non-specific, so that it is shared between the railway and the person to whom we're putatively letting out rights, does it have to be considered for valuation purposes, by looking at on what days it's being used by one and on what days it's being used by another?
Yes, it is relevant to valuation. It might not be. You might not look at the days. You might simply look at the overall split of use. So if it was 70% to Network Rail, 70% to JCD, 30% retained to Network Rail, that split would be reflected, no doubt, in the sum which JCD are willing to pay for the right. And then when the valuation officer comes to value the right, the first thing they would look at is how much JCD have paid for it. And so that it would feed through into the valuation, the fact that the right was not to advertise 100% of the time.
But then doesn't the valuation officer first have to identify the extent to which it's been used by Network Rail? You have up to £400,000 worth. If one's looking at a particular sign in a particular railway station that is being rated, does the valuation officer have to look at how much of the time that was being used by JCD and how much of the time it was used by Network Rail?
On the facts of this agreement, it might be possible simply to look at what JCD have paid on the basis that it's a right to use reasonable endeavours. Sorry, it's an obligation to use reasonable endeavours to try and make available that amount, which would have reduced perhaps the amount which JCD are willing to pay. Whether in fact Network Rail did exercise their retained right will be after the event and might not affect the value of the right.
I can understand that if the hereditament is the right whether or not exercised. But if the valuation is taking place on the exercise of the right, how does that work?
Well,
I think you may be going to get some help from behind.
yes, I mean the right is being valued. The right is what has been paid for is the right subject to the potential for Network Rail to be able to advertise for a portion of the time. Whether in fact Network Rail have called on that right or been allowed to exercise that right, whether that affects the sum payable and the right payable, I suppose it might be fact specific, but the valuation officer might well think that it can be done by the price under the agreement.
So, I mean, in relation to a particular sign at Liverpool Street, which is being valued for rating purposes, the valuation officer, you say, doesn't need to see whether that has in fact been used for half of the year by Network Rail, but he does need to look at the agreement and form some view as to the value of that by reference to the right of Network Rail to use it.
I'm instructed that the valuation officer would make inquiries as to what was going on the facts.
Well, is this one way of looking at it? You've got to read this in context of the agreement as a whole. This is essentially, on your submissions, an agreement to provide to let out an exclusive right to advertise. Network Rail's interest in that major respect is they get a share of the profit. So they have an interest in that income being maximised. And in practical terms, what the advertising companies do is they run campaigns. They run ads, the same ads across a number of sites, of which these will be just a sample. But the focus is on maximising the advertising revenue and profit. What's happening within that context is that it's not exactly a carve out because it's not for a specific amount of time or particular sites, particular days, whatever. I mean, this is of course applicable to a large number of advertising spaces even. This is part of the omnibus agreement. It's not specific to one or two signs. It's potentially exercisable across one or more of them.
Yeah.
And it's just a value of 400,000. It's almost like there's extra consideration being provided by Deco for this facility. It's almost like it's the minimum rent, or alternatively the share of the profit, plus up to this amount.
Yes, and if that wasn't there, the minimum rent
in the context of what you say is an overarching grant of a right of exclusive advertising.
Yes, so it would simply feed into the payment arrangement agreed on. And if it wasn't there, the payment arrangement might be marginally different. It's that sum over the entire, as the Lord says.
So you would expect Deco to be paying a higher rent if they weren't giving this away within the scope of their right of exclusive advertisements.
Yes, exactly. And it is, as my Lord says, it's all 18. It's all stations. It's the entire across the omnibus agreement. That
it's a wider point than the one I was seeking to make. It's not just the 139 whatever it is of one station. It's the 18 stations. It's okay.
Thank you. In a sense, it's more a point for Miss Ward than it was for you.
Yes.
It looks like
Miss Ward has given him the point. And
it looks like there is an answer to the point. I'm going to delegate that if I may. So that was clause 18. Clause 4 was where I was going next. And my learned friend focuses on clauses 4.5 and 4.7, but I think it must be it's important to see them in the context of the rest of clause 4, which starts at page 20, which deals with adjustments to advertising space. And the effect of clause 4 as a whole is that there is a contractual ability to modify the scope of the agreement during the term of the agreement. And the agreement can expand or contract. And importantly also the payment provisions adjust accordingly if that happens. And 4.5 and 4.7 are just one facet of that. So at clauses 4.1 and 4.2, it deals with, as it's been put in bold, an additional station coming on the scene and being incorporated into the agreement. That's 4.1, and then 4.2 adjusts the minimum payment, increases accordingly to account for that. And the profit share, as Lord Justice Nugee said yesterday, would also reflect any modification because it's inherently flexible in that respect. So that's an addition. 4.3 and 4 over the page 21, deal with when Network Rail dispose of an entire station. The upshot of which will of course be that the advertising right in that station is lost. And that's and then 4.3.3.1 to 3.3 also then has consequential provisions in terms of the payment, and the minimum payment is adjusted again. 4.5 and 4.6, thirdly, focused on by my learned friend, they're another aspect of that at a more local level, where rather than a whole station being disposed of, it's simply withdrawal of a single advertising space or disposal of one site. And in that context also, you get the consequential adjustment to the financial provision. That's 4.5.1, which references 4.10, which we looked at yesterday. And essentially, in some circumstances, the minimum payment is then adjusted accordingly. So that's a more limited form of adjustment, 4.5 and 4.6. 4.6, I say, is important because it precludes the right, the withdrawn site being offered to any third party. So that's an aspect of the exclusive nature of the right. And I say what is going on there, the Upper Tribunal at paragraph 62 were correct to describe it as akin to a power of termination of the right in relation to an individual site rather than a power of relocation, as was found in Ludgate House. Then continuing on through clause 4, 4.7 is again more limited form of adjustment, the right to temporarily disturb, remove or obstruct a site for a non-exhaustive list of reasons, but the reasons given are essentially operational reasons for a breach of the agreement, which gives an idea of what it's envisaged to cover. And that's a lesser right than 4.5 and 4.6, and again is not inconsistent with the right having been let out, because it may be temporarily obstructed, but the right remains let out during that temporary obstruction, and no one else can use it for advertising during that period. And once the interference ceases, the right can be enjoyed again. So that's 4.7. That was the second of the two clauses particularly relied on by Mr. Klinsky. Then 4.8 power to close a station for identified reasons, and 4.9 has a associated adjustment to the payment arrangement. In some circumstances, it has to be closed for more than 10 days by reason of 4.9 for any consequential effect to be felt on the minimum payment. So I say clause 4 as a whole is part of the definition of the right, or the extent of the right to advertise. Individual sites can be terminated under 4.3 and 4.5, and they can be temporarily affected under 4.7 with consequential price adjustments. But again, the effect of all that can be priced in by JCD when it makes the contract in the first place, and if those adjustment provisions weren't there, the price paid might have been different. But it doesn't affect the fact that a substantive right has been let out. Those points go to valuation again. My learned friend in oral submissions talked about JCD being subservient, or JCD's right being subservient to Network Rail's operational requirements. In my submission, that isn't a helpful way to characterise it. A more neutral and useful way to characterise that, say, is the advertising right granted to JCD is crafted so as to be compatible with and not conflict with the fact that it exists within an operational railway station, but it's still a right to advertise. So that's clause 4. The other provisions which my learned friend mentioned were concerned the fact that JCD was granted rights of access under the agreement, but subject to restrictions. And I don't go to them, but they were clause 6.1, clause 12, and clause 19, which essentially enabled Network Rail to impose restrictions in terms of personnel and times of access and things of that sort. I say all that is an inevitable function of the sites being on an operational railway station. You see it to an extent in other forms of hereditament, the fact that a shopping centre might shut overnight and therefore no access would be available to its tenants overnight. This is another species of that, essentially. And it is also, there's a clear parallel in my submission between this and the fact that in Southern Railway, the station operator could close the station and impose conditions on access, and that didn't affect the separate hereditaments for the bookstores, etc., coming into existence. So I say that doesn't take it matter any further. The next was about pricing control. There were submissions in writing and briefly orally by my learned friend about to the extent to which Network Rail had some control over pricing. The extent of that largely is within clauses 6.16 and 17, which are about ensuring that JCD doesn't sell the space, the advertising space, in a way which would undermine the profit share, for instance, by discounting more heavily Network Rail sites in order to promote its business elsewhere. But that is simply in order to give effect to the profit share and make sure it works acceptably. Importantly, what I say, and what the agreement doesn't contain, is it does not give Network Rail any role in or control over JCD's advertising business, whether by way of significant control over pricing or strategy or choice of adverts or otherwise. So JCD is left to run its advertising business, essentially. there's the on the same theme, there are the key performance indicators which my learned friend referred to. So there, clause 7 refers to them, and then the clauses, the performance indicators themselves are at page 49, schedule 2. If I could just briefly go to that.
Can you give me the page again?
Page 49 of the bundle, schedule 2. And there are 6 KPIs. They're largely concerned with complying with the contractual agreements, with the possible exception of the penultimate one, net revenue. And there is a, you can see what that says. Rather than exercising control over JC's business, it's simply explaining what Network Rail expect to be achieved, and importantly, provide some metrics against which to judge if Network Rail are thinking about terminating the agreement. In my submission, in any profit share agreement, you might well expect to find such performance indicators. Then the only other control in terms of the content of the adverts is, or in terms of the business, is clause 16 and schedule 3, which is over the page at page 51, which is the code of acceptance, which is essentially prevents adverts which might be considered objectionable. And again, that would go no further than what you'd standardly see in a lease in respect of use. So that's the agreement, and I say it simply doesn't support the suggestion that a right has not been let out. There are 2 final points subjects I wanted to cover. The first was about Mr. Klinsky's submissions about mutual benefit or shared purpose. And the suggestion that there is, in this agreement or in practice, a mutual benefit and shared purpose, such that the court should conclude that there has been no right let out. In my submission, firstly, care is needed in respect of this concept of mutual benefit or shared purpose, because in almost any commercial agreement, there will be mutual benefit, otherwise the parties wouldn't enter into it. But obviously the further point put by Mr. Klinsky is that there might be additional mutual benefit that you see in the Cardtronics example of the ATM attracting people to the superstore and then taking cash out to spend in the superstore. In my submission, that kind of additional mutual benefit or shared purpose is simply absent from the facts of the present case. And there are, from case law in my submission relied on in this appeal, there are essentially four examples. There's firstly Cardtronics with the ATM. As I say, there's obvious mutual benefit going on there. Not so in the present case, because Network Rail are not in the business of advertising, and there's no, other than revenue generation, there is simply no extra benefit for them. The second example is Ludgate House and the property guardians. In that case, there again in my submission is clear mutual benefit, because in addition to the property guardians paying a license fee to the owner of the property, the property guardians, by being in situ, fulfill the purpose of discouraging other use of the property or trespass. So there is clearly more going on than simply revenue generation there. The owner is using the property guardians to perform a service for them, essentially. whereas in the present case, Network Rails is concerned with getting passengers from A to B. It is not concerned with commercial advertising other than as a source of revenue. And in the language of Cardtronics, which I don't go back to, but it's in the paragraphs 41 and following, where the Lord Carnworth asked the question about whether what is going on is a distinct business activity. In Cardtronics, the provision of ATMs was not a distinct business activity because it was bound up with the retail activity that the superstore was going into, whereas here the commercial advertising is a distinct business activity compared with Network Rail's activities. So that's the second example. The third example is Esso, Petroleum and Walker, where in that case there was an express agency agreement between Esso and Roadchef. So it was an agency relationship rather than anything else. And essentially, Roadchef were put in place to fulfill Esso's business of running a petrol station. There was no distinct business activity. And then fourthly and finally it's not a separate case, but it's the lodger example from originally Holywell Union and then picked up in Southern Railway and Cardtronics. Occupation by a lodger is the business that the landlord is engaged in. And in that case, there's clear common purpose. Again, commercial advertising is not the business that Network Rail are engaged in. So that's the mutual beneficial shared purpose. And then finally, there's the point about evidence of use on the facts. And Malone and Friends' criticisms of the Upper Tribunal for the relative conciseness of their treatment of the facts in this case. I say that criticism's unfair because Network Rail, the appellant in this case, rightly concedes that the terms of the 2010 agreement should be the focus of the inquiry. And the evidence of what happened on the ground is secondary to that. The reference to that's appellant's skeleton, paragraph 89, if required. The Upper Tribunal essentially took a similar approach, looking at the agreement first, and then going on to look at the evidence of use, but doing so relatively concisely because the focus was the agreement. In terms of what that evidence did show, I say the Tribunal's summary and analysis of it at 61-62 was entirely sufficient and fair. And if I could get his pages, core bundle, page 90 and 91. There were obviously, in the present case, 2 advertising sites used as sample sites. One of them was a static site, so no interference with that. Victoria Station. The second was a digital site, Liverpool Street. There was some evidence of taking that over to provide messaging in the event of disruption. But rather than go through the evidence, can I refer the court to, it's the Valuation Officer's skeleton at paragraphs 66 to 73. And in short, in a 4-year period, the Liverpool Street had been, digital right had been taken over 4 times for a period of minutes or hours.
So 66 to 73 of
the Valuation Officer's skeleton argument.
Oh yes, yeah.
my learned friend made an additional point, was that it's not fair just to concentrate on the sample sites because they're samples only. You need to look at the whole picture. But the references in our skeleton 66 to 73 in my submission do look at, in fact, the whole picture, which shows a similar picture. And just dealing with what the Upper Tribunal said, it's on page 91, within paragraph 62, at the top of the page. As I understood it, my learned friend criticised the Upper Tribunal for focusing only on the sample sites, whereas in my submission that is a misreading of the decision. It's not what they've done. So if pick up from the 5 lines down from the top of the page, the sentence beginning, the latter entitlement. The latter entitlement is the right to make use of rights where required to display messages. And so that sentence, the latter entitlement is used infrequently in relation to individual sites, plural, and only then for digital sites, plural. And we do not consider that it detracts from it. Detracts from JC Deco's control of the sites. So it's clear there that the Upper Tribunal is not just considering the single static site and the single digital site used as sample sites. It is considering the evidence of how the sites generally, as set out in the evidence of Ms. Jarman-Smith and Mr. Wood, what they were used for and how they were interfered with or otherwise. Then, to the extent that there's an additional point about not only interference by putting up messages about disruption, but also interference due to station redevelopment or things of that sort, that's also covered within paragraph 62. And essentially, the Upper Tribunal were entitled to find that that did not mean that no right had been let out or the right had been negated in such a way that it couldn't be considered to be let out. So that point dealt with as well. Just check. So, Lords, that's what I have to say on ground 3, and unless anything further, those are my submissions. Thank you.
Well, did you want to say anything else on the point?
Just to answer my Lord's question about section 28.2, there is an equivalent in the modern statutory scheme. It's regulation 15 of the non-domestic rating alteration of lists and appeals regulations, England regulations 2009, serially amended but still in force. And that provides, in summary, that the list is only to be altered by consequence of the creation of an advertising site, hereditament under 64.2, either effectively in the terms of section 28.2, either when the structure is constructed or the right is an advertisement is displayed. So in terms of when it comes into existence and goes into the list, there's equivalent provision to section 28.2. Insofar as what my Lord was asking was whether the right continues to exist or be rateable at times after that when it's not exercised, the alteration of lists and appeals regulations, as perhaps might be said, to be apparent from their title, affects when the list is altered. So the site goes into the list. It doesn't then say it comes out every time it's not exercised for a few years. So it doesn't require ongoing monitoring of the extent to which it's used. The fact it's its first use or construction of structure that engages the provision to put it into the list.
So that would suggest that for section 64.2 purposes, it is the right, not the exercise of the right, which is the hereditament.
It's the right, not the exercise of the right, it's the hereditament, but the hereditament does not go into the list until it's exercised in some way, yes.
Are governed by what was originally in section 9 of the
practicalities
in the regulations you're referring us to. Is that what you're saying?
perhaps not exactly, because the valuation officer is required to maintain a list of all hereditaments. So if the hereditament comes into existence under section 64.2, ordinarily the valuation officer would be required to put it in the list as of that date. But section 15 modifies that requirement on the valuation officer, says that the date for putting it in the list is later.
That makes sense, isn't it? Because 65.8 is saying deemed occupation, and
Yes.
there's an obligation to charge rates on hereditaments in the list.
Exactly that.
So this stops.
It stops
that
rates being charged
happening
until it's
before.
yes.
Yeah.
Exactly that. So that's just to answer a lot's question. Unless I can.
Do we have the?
You don't have that. We
Would it
can.
be possible for that to be sent
Yes,
through?
I can PDF it and send it to.
Well,
If someone gives me an email address, I can do that either straight away or at the end of the hearing.
I think what Mr Flanagan said you were going to deal with was my inquiry about what the position is where you have shared use of the advertising rights, and the sharing is not identified by a particular day of the week. It is simply, in general terms, as a percentage use of the space or a financial measure of the use of the space. Does the valuation in that case
Take that into account.
take that into
Yes.
account?
Oh.
And
It
if
values
so,
the
how?
right that is it values the right that is granted. So if the right there is a value that would be attached to a full-time right, so to speak, an exclusive right to such as we have in this case. If the right in this case was subject to Network Rail being able to advertise 20% of the time, for example, then it would probably be worth 20% less. I don't have this, but that's an evaluation
Every
question.
valuation officer for every billing authority would just do a 20% discount across the board on all the signs. Or
I can't tell you precisely. Well, I can't tell you precisely how how each site is valued, because we haven't got to valuation yet in this appeal.
That wouldn't be valuing the exercise of the right if in fact it all took place at Birmingham New Street, say. For most of the time it was used for the railway company's purpose. Surely the valuation officer for Birmingham New Street in relation to a sign there ought to be taking account of what the actual use is at that site.
I think that would be right in the context of a different agreement to the one that we have.
Well, I understand that, but I'm just trying to
Yes.
just to look conceptually
Yes.
at how it works, but because as you can tell from where I've been intervening, whereas you might have to identify a single occupier or land hereditament.
Yes.
Or an advertising right, those rights may be shared.
Yes, and
Just trying to work out how it works in practice.
well, I'm not sure how much I can assist you, just how it does work in practice. I might be being handed something. What I can say is that it does happen in practice. That this wouldn't be something different to if this appeal were to be dismissed, if my client's case were to be upheld. My client would simply treat these sites in the way that it does other sites under similar agreements. You know, this is JC Deco's business. This is what it does. It has similar agreements with supermarkets, those sorts of entities. And these questions will arise in practice and will be dealt with. And the way in which they are dealt with, of course, is capable of being the subject of an appeal to the tribunal and ultimately to this court if it said that my client is getting it wrong. But it's not a new question.
Thank you. Yes, Mr. Klinsky.
On round one, may I ask the court to start on page 14 of the authority fund, which is section 64. And I go to this because section 64.2, page 14 of the authority fund, because in discussion with the court, there were times that the point was put by your lordships on the basis that what we're dealing with in terms of advertising is a deemed hereditament, in my respectful submission, that is a mischaracterisation, and I say that for this reason. I accept at the outset that we're dealing with a special category of hereditament, and I absolutely accept and have always accepted that where that hereditament exists, there are deemed occupation rules, but we are not dealing with the deemed hereditament.
What does that mean?
Well, let me explain, my lord. If you go to section 64(2), you've got the opening words, which is in addition, a right is a hereditament, it's a right to use any land for the purpose of exhibiting advertising. So that's the premise of the exercise of the identification of the hereditament. But then it says, and it's that the right is let out or reserved to any person other than the occupier of land. So one, in my submission, one cannot and should not conflate the premise which gives rise to that with the control, the additional control mechanism that Parliament has put in here in subsection A by the use of the words let out. And if one says it's a deemed hereditament, then it doesn't say there shall be a hereditament if there is a right to use land for the purpose of advertising. It's only if it's let out, and it's only if it's let out to someone other than the occupier of land. And central to my case is that that inherently puts into play what, if anything, is the relevant relationship between the host occupation and the advertising use. And so that, now my learned friend, when was asked about, if you like, the concept of let out and how that fits within the scheme, my submission on her submissions is that it boils down to the proposition that any creation of an advertising right is let out. My essential point is that actually conflates two stages under the statute. And that goes to the heart of the description of Network Rail's case as ironic, because it's said that it's ironic that because Parliament has deemed under section 65(8) to say how you approach occupation when it exists, that it's ironic to introduce any concepts that have anything in common with paramountcy to the stage of thinking about whether hereditament does exist. But I say that's inherent in the fact it's a separate stage under the statute, and it's inherent in the fact that Parliament has chosen limiting words that serve a function by introducing the concept of let out. Now, if that's right, we need to grapple with what let out means, and what that, and when you, my submission is when one tries that, and I'm grateful to the bench for engaging in that thought process in terms of the concept of exclusivity, and when it might apply and when it won't apply, and whether there's any other factors, and the Upper Tribunal clearly tried to do that in paragraph 56. But my submission is that when you try that, you find that you cannot wish away the need to characterise and evaluate the relevant relations. Because it's easy to see how an unconnected advertising on a flank wall of a shop is intended to be caught. That's the paradigm case. That's the example that's given in the leading textbook as to why we need this right. But once you start to think about it, and once you recognise that there's a rich tapestry of life where there'll always be nuanced situations, you need to actually engage in the exercise of thinking about what the discerning criteria is to differentiate a let-out situation from the mere existence of a right to use land for advertising, which, as I say, is the condition, but not the function. And the vice, the central vice of the Upper Tribunal's approach is that it excludes from that exercise any questions of control or complementary purpose. And I say that that doesn't follow from the recognition that it's separate regime, and it doesn't follow from the deemed. And to then say, well, because it's separate and because there are deemed rules, it has to be self-contained, my submission is that's a non sequitur. It wrongly turns away from helpful jurisprudence, which can be applied and adapted as necessary to give an evaluative framework to what the essential qualities which amount, I say, to a letting out, which, as I said in my primary submissions, is about a sufficient separation. If I may then move.
I understand the point you're making about the use of the words deemed,
Yes.
but I think the purpose of using that language is to say the rules that are applied under subsection 1 aren't being applied under subsection 2. I mean, the link with rateable occupation, for example, the 4 characteristics of rateable occupation in the John Lang case, none of that is imported into subsection 2. On your submission, respecting it, you say you apply the language in subsection 2 as it stands, the whole of it, not part of it, the whole of it. But that's all you need to do, even on your submission.
Yeah, but my lord, I accept that.
Subject to the argument about what is meant by let
Well,
out, and
yes.
does it have a qualitative aspect?
That is the central argument. It's not answered by saying the rules of occupation. My submission is it's not answered by the recognition that when the hereditament comes into existence, you don't worry about the occupation stage. It's also not answered by the fact that in a situation where you are worried about occupation and you need to identify the hereditament, the two are intermingled. But that doesn't mean that in a situation where you've got to grapple with an evaluative step to thinking about which of the use of advertising, which uses of advertising on land are let out, that is an evaluative process. And the problem with my learned friend's case is it collapses away that evaluative process. And the problem with the tribunal's decision is it rejects helpful learning that could have been tailored as if it were an issue of principle. And why does it do that? It does that on the basis of 2 reasons. One, a construction of the statute that in my submission is overstated. And second, a thought process about the central list, which I'll come to in a moment. So that's where I say that there is a difference. May I then move to the question of the central list and the Miss Ward's table is helpful, but I would respectfully submit incomplete. But what it does show, beyond any doubt at all, is that if this court thinks there's any value at all with looking at the historic development of rating law and understanding the 1988 Act in the against the prism of what came before and forming a view about whether things have changed and if so, why and how, then what you can only do that on her table and her case by reading together the 1988 Act and the central list regulations. You simply cannot do it without doing that if you're thinking about railways and advertising. Now, when you do think about that, we know that in the General Rate Act of 1967, there was a bespoke approach to advertising at railway stations. I have in particular in mind section 28.6. We know that the 1988 Act moved railways from primary legislation to secondary legislation. We know that when they did that, they re-provided what was section 32.2, i.e. the railway hereditament of the General Rate Act, into the 1989 regulations as they then were, through the concept of the accepted hereditaments. That's exactly where section 30.2.2 is implanted, but it isn't a straight implant, it's an implant with adjustments. And what did they do? Well, they added 2 concepts. They added the express indication that advertising at railways was a railway purpose. They did that through the definition that I can show that the court is familiar with. But also, they added in the concept of an accepted hereditament is rights let out so as to be capable of assessment. So if my Lord or Justice Popplewell is thinking about how this relates to Miss Ward's table, my submission is that there is a mistake by keeping these columns blank after 28.6, and what one should insert there
After, sorry.
after 28.6. So on the top of page 2, you've got the 28.6, and you've got the 4 blank columns. And what you actually need to write in there, I would respectfully submit, is a twofold change to the railway hereditament by the addition of rights so let out to the concept of an accepted hereditament, and by the addition of the definition of the railway hereditament. Now, she attributes it elsewhere in part, but my submission is that is a plain response to the need for a bespoke treatment of advertising at railways. It may be a different, but it is part of the response. And if that's right, then the proposition is, I respectfully say, that advertising rights at stations, if the right approach is that you never get into Regulation 6, then that that legislative change makes no sense. My Lord Justice Holgate put it that it was merely confirmatory, but that is on the premise that you don't get into the inquiry that regulation. I say Regulation 6, it's now Regulation 6, it's different. The accepted hereditament in the 1989 or the Regulation 6 in the 2005. You don't get into that inquiry. But my submission is that approach actually undermines the change that Parliament made. If you formed a concluded view on the question of 64.2 in the context of railways before you consider Regulation 6, then you make necessarily and for all purposes the definition of accepted hereditament redundant in relation to advertising rights. So the construction is that Parliament acted.
Is that just subparagraph C?
Yes.
Sorry.
Yes, it is. Yes, it is. But that's forgive me. But that's where the change was made.
Yeah, I appreciate that.
And it's only right. But yes, exactly. So we need, in my submission, that's an unlikely construction. That change was a completely otiose change, and I cannot think of a single example. If you ask the prior question of, is this? I form a view on section 64.2, and I use that to define whether I'm bothered about advertising rights at stations under accepted hereditament in 1989 or Regulation 6 in 2005. And if you do that, then you necessarily render the change that Parliament made redundant, because it can never be putatively in and then taken out. So the very change they made in response to section 28.6 is one that is necessarily redundant on the Tribunal's analysis in paragraph 48 and Miss Ward's submissions. And my simple submission is that is an utterly implausible reading of the change that was made when you think about it in the context of the legislative history. I appreciate the time, Lord.
Yes.
Would you rather I finished, how much time you would allow me?
Yes, because we're not proposing to set this on.
No, so may I go on for 10 more minutes? Or is that
Yes.
I'm
No
extremely grateful. So my submission is that you don't get into that problem, because my submission is that on the face of the regulations themselves, the only sensible way to think about how accepted hereditament can work in the case of advertising is to take the natural unit of occupation of the whole station, Victoria Station or Liverpool Street Station, and then to think through the various stages, which takes you to the proposition: is it a hereditament? Is it an advertising right that's capable of separate assessment? Now, on my case, that's actually the same question reached by a different route, but it causes the valuation officer's case and the tribunal's analysis a problem, because it's their analysis is based on the idea that that's a qualitatively different question than the simple let out question in 64.2. And my submission is it isn't. And in any event, in a railway case, you have to think about, is it an advertising right that's capable of separate assessments? Now, yesterday there was a discussion about the viries of section 53.2 of the Local Government Finance Act, and it was the point that was raised by my Lord Justice Nugee was, is the viries predicated on the proposition that you need to have you can only designate, if you like, in relation to occupation. My submission is that isn't the right approach. That's not consistent with how Lord Wright dealt with the matter in Southern Railway, but more fundamentally, if you just think in terms of the 2005 regulations, which are at tab 3, if we think about the position of the British Transport Police, which is within the proviso in B, in that situation, that unit is, within these regulations, occupied by the British Transport Police. So if my Lord Nugee's proposition that you can't get into the, well, not proposition, but thought in terms of the question of the viries, you can't get into the central list unless it's occupied. Well, here you've got something that isn't occupied by Network Rail. It is occupied by another body. It's part of the railway hereditament by these provisions. And then when you get to the end of the process, you get to subsection 5, it deems it to be occupied by the relevant designated person. So it can't be that you only get into the machinery of this if you've got something that is occupied by the hereditaments. And my solution is the way that that works in the machinery is that you only get into the local list if you are not on the central list. You need to think about the Regulation 6 railway hereditaments. I would say, consistent with Lord Wright and consistent with the logical approach to it and consistent with the amendment made in terms of the central list regulations, by thinking about the natural unit of occupation and seeing if anything is carved out of it through the mechanism of accepted hereditaments. And it's only once you've done that exercise and you've concluded that it's not in the central list that you say, okay, well, it's in the local list, and that's the point at which the question of who the occupier of it is relevant. Or to refine the point, actually, it's once the right's been exercised that the question. So it's a subsequent question. I don't rely on the useful clarification by the SWORD. I make the submission anyway, but actually the exercise of it puts the point rather beyond doubt. The function of the deeming only comes in if it's in the local list. It cannot drive the approach to the central list. So my respectful submission is all roads, structurally understood, lead to the idea that you have to grapple with Regulation 6, and that is a fundamental departure from what the Upper Tribunal did in paragraph 48, and it's fundamentally contrary to the distinctions that are at heart of the valuation officer's argument before this court, and that is, I'd respectfully say, a category error on their part, and the correct approach, understood in the prism of history, is you start with Victoria Station, you then, it all turns on, is the right let out so as to be capable of assessment, and that is, I would say, an exercise in looking at its qualitative nature that, on my submission, is consistent with what you actually need to do anyway under section 64.2. And so, my lords, that's granted. I don't propose to say anything on ground 4 other than to pray in aid that the consequence of the discussion is that this will, the atomisation of advertisements will be an enormous administrative burden for, in this case, JC&Co and Royal Network Rail, the Valuation Office, the Collection Authority, and in my respectful submission, a proper reading of the statutory scheme is that that does not reflect the intention of Parliament when they enacted the 1989 Central List Regulations. In terms of ground 3 and the submissions of my learned friend Mr Flanagan in the 3 minutes I have available, at this stage of the analysis, ground 3, we are in the qualitative evaluation. My learned friend's submissions all come down to there's nothing that negates the advertising rights properly understood. But that, in my submission, is to ask the wrong question. The question is, has the advertising rights been let out from the host hereditament? And in that context, I say the Ludgate House emphasis on understanding the contractual provisions is critical. I say that 4.5 and 4.7 of the 2010 agreement place at the centrality of the analysis the subsidiarity, if I can put it that way, to the functioning of the railway hereditament. And if you then think, and this is paragraph 90 of our main skeleton, if you then think through the prism of the SO case, one thinks, well, look, there's what type of control is in existence in this agreement? Well, there's very little substantial control or unusual control that regulates with the business as usual situation, the exercise of that, and because JC&Co is a trusted contractor to deliver that, but they're delivering it on my submission in furtherance of Network Rail's purposes, its statutory purposes, of railway purposes under this Act. And in any event, I say there is evidence, and just for my Lord's reference, paragraph 13 of Mr Wood's evidence at page 139 of the supplementary bundle dealt with the connection of advertising with railways in terms of having interest, etc.
So that reference again is
paragraph 13, page 139.
Of the SB.
Yes, so there's two types of control going on. One, which is you let the expert get on with it, and the absence of control is not, or the absence of interference is not an absence of control. But the more important thing is that everything they do at every moment is subject to very profound rights of intervention in 4.5 and 4.7 during the subsistence of the contract to give the primacy of the underlying occupation. And that does go, I say, to the relevant question as to whether there has been sufficient separation from the advertising with the land.
The primacy of the underlying occupation
Yes.
being
the running of a functioning operational station. And I do rely on
that's what I thought you
words.
meant. But I
Yes, forgive me, but thank you. And just very briefly, Network Rail's rights to display adverts is not the main focus of my inquiry, but my lords, one does need to think about that correctly. There's three places there. There's clause 3.3, which is the right to advertise things on their station anyway, including displaying signals. There's the allocation under clause 18, which, if that was all there was, it would be a very, very different case. I accept that's consistent with what one might call a business as usual advertising right. And then I say paragraph 4.6, properly construed, prevents the appointment of a new concessionaire, but it does not prevent self-advertising by Network Rail, them commissioning adverts on their own. And finally, my learned friend sought to defend paragraph 62 of the Tribunal's reasoning by saying that they had focused on the practical operation of all of the hereditaments. Now I see why he says that, actually looking carefully at what they say, but he also says we concede that the relevant approach is the agreement. We don't concede that, we positively assert the relevant processes and construction of the agreement. We rely on Ludgate House, and the vice of the Upper Tribunal's analysis is that when you get to clause 4.7, the temporary interference, they did not in fact rely upon an analysis of the agreement itself. They relied upon the practicality of its use. That was a departure from what the right approach was, and they then drew what I respectfully submit was a false parallel with Case, because in Case there was no question of the railway undertaking coming in and overriding a desired use of the members' club and saying, sorry, our operational requirements prevail, which is the function of 4.7. So that is I respectfully say, a false analysis that they've put in there, false equivalence. So they haven't properly analysed the agreement, and the very threadbare findings, I respectfully say, cannot stand if I'm right on the main points in this issue. In other words, less I insist, those are my submissions.
Thank you. Thank you very much to everybody. We will reserve our judgments when we come to deliver them. They'll be handed down in draft in the usual way for typographical or other administrative corrections, not re-arguing the case. You're all aware, but you just make sure that everybody who might have a copy is aware of the stringent restrictions on the use and distribution of the agreement, and it just remains to thank you all very much for what's been a very interesting case.
All rise if able.